Hi everyone, this is Marvelyn Miles on the channel you know very well by now, The Law Seeker. Glad to have you. I am hoping to give you some good nuggets this evening. A question came in and I'm going to read it to you. It says, I am a legal research scholar and presently I am in the USA on J1 visa status. Am I subject to the 2-year home country requirement? If so, are my spouse and children who have J2 status subject to the same requirement? Now, I'll give you the disclaimer, first of all. This is not going to be legal advice. Of course, we're talking law, we're law seekers, but in order for you to consider this legal advice, you need a professional legal agreement setting out the terms of the professional relationship and the scope and so on and so forth. So take it as you get it. This is where you get the unadulterated law, no distractions. What you see is what you get, okay? Straight as an arrow. And if you find it necessary to want more information or want representation, then of course you need to get an attorney. And that could be me, that could be somebody else of your choice. If you want to reach out to me and my team, we'll be happy to assist. My details are on the page. You're welcome. And I'll be happy to assist you and honored. All right, so let's get right into the answer, which is to be taken subject to the disclaimer. A person who holds a J1 visa status is a non-immigrant. Now, what that means is that the person can only remain in the United States of America in accordance with the conditions of the Form DS 2019, that is the Certificate of Eligibility issued by the USCIS. The period of valid status usually extends only until the end of the exchange program in which the person participates, but an additional 30 days of grace period is allowed to facilitate preparation for departure to the relevant home country. This requirement to depart extends not only to the J1 visa holder, but to the J2 visa holders as well. So if there's a wife, there's a child who accompanies the J1 visa holder, they would come to the United States of America as J2 visa holders, and they hold their status by virtue of the J1 visa holder's status. So they are dependents of the J1 visa holder. And whatever conditions apply to the J1 visa holder automatically applies to the J2 visa holders. So the departure applies to them equally. When the J1 visa holders are required to serve what is called the 2-year home country physical presence requirement, that condition also extends to the J2 visa holders. And so sometimes it is better to think ahead and not really come to the United States of America as a J2 visa holder. And that is for another time. We'll talk about that. The 2-year home country physical presence requirement does not occur in all situations. In other words, not all J1 visa holders are subject to this requirement. In order to be subject to this requirement, there are certain conditions that must apply. Firstly, the exchange program would have had to be funded, either wholly or partially, by the home country government or by a U.S. government agency or by an international organization which received funding from the U.S. government or that of the home country. Secondly, if the exchange program was a graduate medical type training. And thirdly, if the exchange program concerns an area of specialized skill or knowledge which has been classified as necessary for the further development of the home country and appears on the exchange visitors skills list applicable to that home country. So those are the 3 program conditions that will cause the country physical presence requirement for 2 years to apply. A person who falls into any of those categories and who is unable to meet this home country physical presence requirement may be eligible for a waiver. So that is the go around, and that waiver, if granted, will extend to dependents. Qualifications have to be met again, and I'll tell you what those qualification bases are. The applicant for the waiver must be able to get a no objection letter from the home country government, which is normally not a problem. You pay a small fee, you get that. 2, if an interested U.S. federal government agency makes the request, that's also a way. 3, if there are credible grounds for showing that if you go back home, you will be persecuted, that's another way. If there are credible grounds for showing exceptional hardship to a U.S. spouse or child, that's another way. If you can show that that will be the case. And finally, if the applicant can show that they are accepted into what is called a Conrad State 30 program for full-time employment in a healthcare facility located in an area where there is a great shortage of medical professionals to serve medical patients. So that's the other way. So as I've said, only some persons will fall into the category, which means that they are obliged to spend 2 years back in their home country before being eligible for another immigration benefit. And what is important to note is that this restriction really is aimed at allowing the home country to benefit from what has been learned by the J1 visa holder, and it is really to foster or assist developing countries. So they want to make sure that this knowledge or this skill or this expertise that the person participated in is going to be used for the upliftment of the home country. So the restriction that requires the participant to go back home and spend 2 years will not allow that person to get an immigrant visa. And it will not allow the person, if in the USA, to be able to adjust status, okay, on the way to a green card. The 2 years must either be served or waived. And I've told you what the conditions for waiver eligibility are. But that doesn't mean that if you go back home, you wouldn't be eligible for another non-immigrant visa, except HK or L category visas. We look at those another time. And if you're in the USA, you could also be eligible for an A or G visa, which we'll look at another time. So it's not all restrictive. You can still go back home, you can travel back and forth, but you will not be eligible for the immigrant visa. The green card is out of the question. Even if you put in the application, there's no problem you putting in that application, the petition for a green card, but unless the requirement is waived, the 2-year home country physical presence requirement is waived, you will have to serve that time, or you can get it waived, as I've said, and that requires proper legal preparation. So I would advise that you seek the services of an attorney to ensure that your application is put together properly for maximum efficiency and success. That means you get your own or you reach out to us. We will help. Okay? So stay safe, and as usual, peace out.